AI v. The Legal Cartel. This is a book with more relevance today than ever before. Not because the system has changed, but because it hasn't. This book is not theory. It's not a misunderstanding of the law. It's what actually happened in a Brampton court case and what the Ontario legal industry has chosen to ignore. This book doesn't just identify one mistake, it's a mirror held up to the legal system itself. And the reflection? It should worry anyone who still believes justice is blind. To start, let's take a simple look at how a court case works. Both sides submit what's called a factum to the court. And true to the name, a factum is meant to provide the judge with a clear and truthful understanding of the issues, presented from the perspective of either the plaintiff or the defendant. In many cases, when the facts are allowed to speak for themselves, justice can be served accurately and honorably. However, there's a powerful force that can obstruct justice, and it's called the legal industry. Lawyers are granted something called legal privilege, which comes with immense responsibility, not least because judges trust lawyer statements as being true. But here's the misconception. Most people believe it's a lawyer's job to establish the facts so that a judge can make a fair and balanced decision. However, in reality, it's a lawyer's job to try and protect the client's interests. Full stop. For over a century, this trust in legal privilege has been open to serious question because it does nothing to stop unscrupulous people from abusing privilege. It's not difficult to understand the concern. When lawyers take on a case, their first move is to frame the narrative. They shape how the court sees the people involved. This usually starts with a pleading that positions their client as reasonable and the opposing party as unreliable, dishonest, or even unstable. Discrediting the opponent isn't always about facts. It's often about perception. They'll highlight anything that casts doubt, and if the other side is self-represented, they may lean on legal jargon and procedural tactics to overwhelm or confuse, subtly reinforcing the idea that only professionals can be trusted in the courtroom. But what happens if professionals can't be trusted in the courtroom? What if the very people sworn to uphold justice are the ones distorting it? When lawyer misconduct is overlooked, or worse, protected, the legal system stops being a place of truth. It becomes a performance, where outcomes are dictated not by facts, but by who can manipulate the process more effectively. And if corruption is allowed to prevail, then justice isn't just denied, it's rewritten, quietly, legally, and dangerously. And that's why this book doesn't pull punches, because when the system fails this badly, when truth is buried beneath procedure and those responsible walk away untouched, silence becomes complicity. AI v. The Legal Cartel isn't just a title, it's a reckoning, a direct challenge to a profession that has visibly lost its moral compass. It names the failures, exposes the tactics, and forces a confrontation the Ontario legal system has tried to avoid for years. Identifying a compelling legal embarrassment, the book highlights a glaring example of systemic corruption. Using the 2012 Brampton court case, Edwards v. Morneau-Sheppel, a malpractice case against a Sheppel guidance counselor, Catherine Heyman, it identifies how Sheppel successfully defended against a claim it had no legal right to contest. And let's just reiterate this situation. All the evidence indicates Sheppel lawyers had no legal right to contest this case. On the surface, it should have been a straightforward case for Edwards to win, but unbeknownst to both he and the court at the time, they were being gaslit by fabricated lawyer statements. This reality being confirmed by a private investigation that later identified Sheppel lawyers had committed to a fraudulent case representation. Filing pleadings they knew to be false, Morneau-Sheppel's procedural maneuvers are legally recognized obstructing justice, and this isn't a vague allegation. The violations in Edwards v. Morneau-Sheppel are confirmed by legal code and due process. What should have triggered immediate condemnation from the Ontario Law Society was instead buried, not corrected, not addressed, just quietly forgotten. This reported case stands as a devastating betrayal of legal integrity. And yet, Sheppel's improper pleading still remains active. Acting as a precedent, it still has the legal capacity to mislead future cases and shield the lawyer misconduct behind the illusion of legitimacy. The book reveals that what once appeared plausible was, in fact, lawyer smoke and mirrors to obstruct justice. Sheppel's senior in-house lawyer, Rosalind Cogan, along with Pamela Meals of the Toronto law firm Aird and Burles, submitted a defense factum that, though accepted at the time, was illegal. And now, more than a decade later, the Ontario legal industry still refuses to address it, despite clear legal code violations confirming its impropriety. Regardless of legal apathy to address this criminal injustice, Chappelle's defense factum can still be identified as entirely fabricated and as such, with no supportable facts relating to Catherine Heyman. The factum's illegality can only render it an improper pleading. Let's be clear, because it shouldn't have to be said. The court's judgment is officially on record as siding with a defense that had no legal standing to anyone actually named in Edwards' claim. Therefore, in plain terms, the judgment can only be an outright nonsense. Reality. Chappelle's factum did not name Catherine Heyman as someone to be defended. She didn't appear in court. She gave no evidence in support of any of Chappelle's factum statements, and she is not on record denying any of the allegations made against her in Edwards' claim. Thus, Heyman's unethical conduct, the core of Edwards' claim, was never refuted. Not by Heyman, not by anyone. And yet, Chappelle's lawyers carried on without her input, crafting a defense as though her involvement were active and oppositional to Edwards. But legally, this clearly cannot be identified as being the case. Add to this, Chappelle lawyers Kogan and Meals substituted an on-point authority for one other that could not be legally quoted regarding the case, and the lawyer statements can only be interpreted as a malicious and criminal obstruction of justice. With Catherine Heyman incontestably playing no part in the defense, the legal position is clear. Morneau-Chappelle lawyers unilaterally constructed a narrative, rewriting the case to suit their own agenda, without any involvement from the accused defendant in Edwards' claim. And that, extraordinary as it is, crosses a legal line. Lawyers are not permitted to initiate litigation without full knowledge and backing of a client. And herein lies the legal issue, not just identifying misconduct, but a criminal matter that demands accountability. But let's just stop for a moment. This overall situation leads to an even more absurd twist. If Chappelle lawyers were acting on her behalf without her knowledge, then, bizarrely, Catherine Heyman of Austin, Texas, despite being the one who committed the original malpractice, might now have a legal claim of false representation of her own against Morneau-Chappelle.
That's insane.
But back to the insanity. A defense this brazen doesn't just raise eyebrows. It blows the lid off a deeper crisis that begs the question: how many other cases have been quietly derailed by lawyers twisting the system to better suit their own needs? AI v. the legal cartel doesn't ask for reform. It demands what the legal world fears most: uncompromising oversight, not someday, but now. It makes the case for AI judges to enter the courtroom, not as a gimmick, but as a safeguard. No ego, no favors, no backroom handshakes, just a judge that can't be leaned on, lied to, or lobbied. Because if lawyers can fabricate justice untouched, then justice needs a new defense of its own, and the only way to level the field is with something that can't be corrupted. AI v. the legal cartel. The reckoning is here. One case, one truth. One line that got crossed. The fight isn't over, not even close. This isn't just a story. It's the resistance to a system that's buried the truth for too long. But before we go, here's one other interesting scenario to think about. If we accept that AI judges can bring clarity, fairness, and discipline to the courtroom, then the next logical step is to question why human legal advocates are still necessary, especially when their role often involves distortion, performance, and strategic manipulation. Imagine a justice system where both sides are represented not by lawyers with vested interests, but by impartial AI advocates. These advocates would be incapable of lying, concealing facts, or exploiting legal loopholes. Arguments would be made on the basis of truth and verified law, nothing more, nothing less. This shift would eliminate the gamesmanship that currently infects many courtrooms. With no privilege to hide behind and no incentive to mislead, AI-led representation would inject real justice into a legal industry that too often tolerates and at times rewards misconduct. Eliminating victims of lawyer fraud, injustice would become a thing of the past. And we must concede, by removing the human corruption from advocacy, we don't just reform the system, we redefine it. Justice becomes what it was always meant to be: clean, honest, and accessible to all. Maybe the future isn't about removing lawyers. Maybe it's about reprogramming justice itself with AI. Advanced integrity. AI v. the legal cartel, available now in paperback, ebook, and audiobook.